Carmen is still upset about that night. She said that she had more rhythm. She had to get his name still talking.
All the lawyers. Oh, yeah.
Somebody else.
Everyone ready?
Yesterday was the first day. Just forgot to check.
He should have been.
All rise, please. United States District Court is now in session. The Honorable James L. Robart, United States District Judge presiding.
Please be seated. The clerk will call this matter.
Case C-12-1282, United States of America versus City of Seattle. Counsel, please make your appearances for the record.
Yes, for the United States government, Your Honor.
Thank you.
Peter Holmes, City Attorney for the City of Seattle. With me today, Your Honor, is Assistant City Attorney Sarah Moorhead, and we're pleased to introduce Seattle's new Chief of Police, Kathleen O'Toole, and her Chief Operating Officer, Michael Wagers.
Thank you.
Eric Bob, Monitor.
Jeffrey Amson, Monitoring Team.
Matthew Barge, Monitoring Team.
Peter Ehrlichman, Deputy Monitor.
Ron Ward, Assistant Monitor.
Thank you, Counsel. We are here at the request of the court. This is not one of our usual scheduled status conferences. However, the court received some time ago the City of Seattle's motion to extend the deadline to submit a request for proposals to build a business intelligence system. And since then, there has been filed a supplement to that motion and an declaration of Maggie Goodrich in support of that motion. When we were last here, the court attempted to make it perfectly clear that it was discouraged by the consistent requests for extensions of deadlines that are found in the annual plans, and that it intended to not approve those in the future, absent a thoughtful explanation of why it was necessary and an explanation of why, what the circumstances were that resulted in that. I find myself today once again in the situation of being asked to extend a deadline, and in this case an extremely significant deadline in the matter of the United States of America versus City of Seattle. I would note that this case bears the caption of 12, meaning that it was filed in 2012-1282. I went and looked and note that that would have been filed in July of 2012. Today is August 19, 2014. The backdrop of events in the United States at this time offers a clear explanation for the reason for the court's concern over the delays in this matter. We have an unfortunate situation in Missouri which has become not a local or a statewide concern, but a national concern. Everyone connected with those events has experienced problems. We have a dead teenager who was shot by a member of the police force. The court obviously offers no opinion as to how that happened because it lacks the facts to do so. However, it is clear to the court that the young man and his family and that community are experiencing great suffering. The police force is been damaged in that there was, as I was driving into work today, calls for the abolition of that police force. Police forces everywhere have been damaged because of the repeated refrain that this is what's going on in this country and it needs to stop. And I would add, ironically, that police officers have been damaged because they are concerned about the community's reaction to their presence and to their intervention in situations and for their own safety. What does that have to do with us? If you go back and look at the Department of Justice investigation of the Seattle Police Department, you will find a number of areas where they found shortcomings and recommended reforms. Contrary to some revisionist history, the Department of Justice investigation was acknowledged and accepted by the City of Seattle when it signed the settlement agreement. If you look at the areas that are found in the settlement agreement, predominant among them are use of force policies, use of force reporting and investigation, use of force training, police stops and detentions, bias-free policing, and supervision of officers. If I were to put those 6 items up and ask, are they issues in the current situation in Missouri, the answer would be yes, 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 and yes. I don't know how to more directly convey the court's point of view that delay of the implementation of the provisions in the settlement agreement is intolerable. How we can be here 25 months later and confronting a request for, in effect, a 9-month delay for a preparation of a proposal to build a business intelligence system is simply not explainable to the court. It is not as if these facts were not known. It is mentioned in the Department of Justice investigation. The city's own consultants were highly critical of the status of the city's business intelligence system, or more accurately, the absence of one. The consent decree speaks to it, what we call the settlement agreement. And finally, the monitor has acknowledged it in his annual reports repeatedly. And against that backdrop, today I'm asked to extend that deadline for 9 additional months. Let me take the drama out of this. I have no choice but to do so. We don't have a system now, and the newly retained consultant advises that it will take a while to develop one. I asked you all here today to answer the question of why did it take us 25 months to find out that we were behind schedule and start to make some changes to this. other topics that I would like to hear discussed from one speaker from the city, one speaker from the government, and one speaker from the monitors team is how are we going to get going in the future? There is some candid discussion in the pleadings that have been filed suggesting that we are a minimum of 3 and potentially 4 years from compliance. The settlement agreement provides that the period of compliance of 2 years is necessary before the court can consider the termination of the settlement agreement. By my math, that's 5 years from now. That doesn't really impact me because I have lifetime tenure. Other people in this audience don't. Some of them stand for election. Some of them operate at the request of elected officials. In addition, I face a police department which contains at least some individuals who feel that their judgment supersedes the judgment of the court and extended their absolutely constitutionally guaranteed rights to file a lawsuit. I would note, ironically, that there was no lawyer who wanted to survive the Rule 11 requirement of good faith, and it was filed on a pro se basis, and it's never been served. But it certainly got lots of attention in the press, which is apparently what it was intended to do. To those individuals, I simply say, get over it. The train has left the station. It's not going to turn around. The good old days are not coming back. I am delighted to have the presence of the chief here today, a courtesy which has previously not been extended and was representative to me of the belief of the department that if they simply could hold out long enough, maybe this problem too would go away. Against that backdrop, I'll hear first from the City of Seattle explaining how we got here. I understand that they want to divide their time, and I have permitted them to do so. That's an exception to the one-speaker rule. So, Mr. Holmes, who's ever speaking. Ms. Moorhead?
Thank you, Your Honor. We very much appreciate that exception to the one-speaker rule because we would like the court, with the court's permission, to hear directly from Chief O'Toole about her commitment to the compliance effort. And we would also like the court to hear directly from the Chief Operating Officer, Mike Wagers, about what is being done now to implement IAPRO and the BI system in a timely fashion.
All right, thank you. Chief, we have a podium rule in this district, which Moorhead knows well and just violated, but that's all right.
I'm sorry, Your Honor.
We do have you pinned in back there.
Good morning. Good morning, Your Honor. Thank you very much. I hope this is the first of several opportunities I'll have to address the court and update you on the progress of the settlement agreement. As you know, I was appointed on June 23rd. I thought perhaps it would be helpful if I just spoke briefly about my background because I think it's there are many aspects of it that are relevant to this project. I started my career as a Boston police officer in 1979 and rose through the ranks of state and local policing in Massachusetts. I'm a lawyer by education, but a police officer by trade. Early in my career, in the early 1980s, I worked with the legislature and the Attorney General's Office in Massachusetts to develop and pass our state civil rights statutes there, and then traveled throughout the state training police officers and prosecutors on those laws. I continued my commitment to constitutional policing by teaching criminal procedure at the Academy for many years. I was an expert for the U.S. Department of Justice Civil Rights Division on the New Jersey State Police case, one of the first police profiling cases. Then I went off to Northern Ireland and worked on development of a new policing model there as part of the peace process, which was in large part all about bias-free policing. I returned to serve as Boston Police Commissioner, and then later, more recently, I also served as the monitor in a case of the U.S. government in an agreement with the East Haven, Connecticut Police Department. So I served as as a monitor working with all of the parties, with the government, with the town of East Haven on that project for the last 2 years. So I know I'm absolutely committed to this work. I think that this is what distinguished me. That work is what distinguished me in the selection process because the mayor made it very clear that the implementation of this agreement was his #1 priority for the police department. I know what it takes to get this done. I've worked as a monitor. I met Mr. Bob 15 years ago when I was working on the project in Northern Ireland. I have a great respect for his work. Since I was appointed here, we've met at least on 1 or 2 occasions each time he's in town. I think we've established a very good relationship, collaborative relationship, a relationship of mutual trust and transparency. And I commit to you, to him, and to his team that will continue. I know that we need to bring a sense of urgency to the implementation of this agreement, and I promise you that I will do that. Because of the concerns raised about the business intelligence project and also management of the police department overall, I made 2 appointments early on. One is the appointment of Mr. Mike Wagers, who will also address the court today. Mike is a nationally recognized expert in policing. He has a PhD in criminal justice, but also worked for the International Association of Chiefs of Police for many years and focused a lot on technology in his work. Also, we contracted with Maggie Goodrich, who has helped the LAPD and has had a working relationship with Mr. Bob in the past. So I think that at this point we do have the ducks in order. I'm sorry that we're here to address the delays that have happened in the past, but I assure you that this is my #1 priority for the Seattle Police Department, the implementation of the agreement. I appreciate the remarks you made today because I think that underscores the sense of urgency that I need to bring to the organization in the implementation of the agreement. So thank you, Your Honor.
I can't hold you responsible for what's happened in the past, but do you have any understanding of why it has taken us 25 months to get around to the business information system?
Well, unfortunately, Your Honor, I think that there was a lot of resistance in the organization, and I think the relationships early on were contentious. I think that was very counterproductive, and that's not the case now. And I think, I know that the city's requesting a continuance today. I think that's unfortunate. I'm hoping that we can expedite the development of the RFP for the system because, I hope that we can actually expedite it so that we'll achieve it prior to the date that is being requested. So, again, I can't speak for the past, but I've made it very clear with my command staff and in all of my meetings with police officers out there and my meetings with the community that this is my #1 priority, and we need to get it done, and we need to get it done expeditiously.
It may be Mr. Majors who needs to address this, but walk me through, let's assume that on March 30th we have a request for proposals that's ready to go. What is the time frame after that?
Okay, Your Honor, I will defer to Mr. Wagers on that. But I will say that, Your Honor, that please know that we are capturing the data at this point. We need a system that will distill that data properly. So we're not losing any time in terms of the data capture. We have several databases. The system will distill that information that's required. And I'd also like to, just one more point, Your Honor, I'm sorry, but we need to do this expeditiously, but in no way do I want to sacrifice the spirit of the agreement in the process. We have to drive cultural change in the organization, so as we move along and we accomplish the implementation within your deadlines going forward, I'm also committed to not just to ticking boxes, but to ensuring that we realize the cultural change and the reform that's required.
Let me ask 2 additional questions, one of which you can employ that excellent style of management by delegating to someone else. First off, do you share a commitment to the importance of gathering this information?
Yes, Your Honor, I certainly do. I think it's really important. And again, based on my experience as a monitor in East Haven, Connecticut, we went through the first year of the agreement and developed all the procedures similar to here. Shortly thereafter, we did all the training was completed, and now we're, in that agreement, I actually went on several occasions and conducted compliance audits. And so I think it's absolutely essential to have all of the information that Mr. Bob has indicated is required. And it's actually within the four corners of the agreement.
It is. It's been there for a while. Last question, Mr. Majors. The court has previously repeatedly expressed concern over the failure to implement the directions in regards to dashboard cameras and officer communication equipment. Do we have 100% compliance with that at this time? And I understand you may not be the appropriate person to answer that.
Again, Your Honor, I know that I've worked with closely with the OPA director on several of the current cases, and certainly the compliance with dashboard cameras is always at the forefront of their investigations. So, again, I don't have a report to present to you today that indicates there's 100% compliance there, but it's my understanding that police officers have been trained and are using the equipment, and that they're being held accountable for using the equipment.
All right. Thank you.
Thank you, Your Honor.
Thank you, Chief. Major?
Thank you, Your Honor. And I can't speak of what's happened in the past, but I can tell you going forward, what will be key in obtaining compliance and more broadly institutionalizing the reforms across the department is leadership. And I think you see that today having Chief O'Toole here, and there's not a day that goes by that we're not talking about this internally. And you certainly set the appropriate backdrop with what's going on in Ferguson. And again, those discussions are happening internally within the police department, set against that backdrop, and also within the context of this agreement. Let me just tell you a few things that we've done, what we are doing right now going forward to try to correct some of the issues that have gotten us here, and how I think we can obtain compliance. One, we made some personnel changes that we thought were impeding the progress of instituting IA-PRO and obtaining compliance. Two, at the recommendation of Maggie Goodrich, we've restructured the project team in terms of how the project is managed, who the business owner is. We, as effective last week, we moved the Training and Compliance Bureau to directly report to me, and now we'll be tracking the progress on IA-PRO implementation and more broadly the business intelligence system. And lastly, on the delay, in which we obviously agree with the motion filed with the court and with the recommendation of Ms. Goodrich, that if we had issued that RFP now, that might have delayed us even more until we get a better sense, and we see this across the department in other ways, of the source systems and the quality of the data and the integrity of the data that will feed into the business intelligence system. If we had issued that RFP, we would have been asking vendors to do something that we don't think it would have cost more and delayed us in terms of implementation.
Well, so the public understands. I want to make sure that I understand.
Yeah.
We're talking about existing systems inside the police when you say business information systems.
Mm-hmm.
They've been around since July of 2012. And what we're now doing is trying to figure out in August of 2014 what they do and how can they feed into another system, or are they reliable in the first place? Is that what you're telling me?
I think we want to make sure they're reliable in the first place, Your Honor, and those are the recommendations of the PricewaterhouseCoopers report as well. And again, I don't think this is unique simply to the Seattle Police Department. I think people are surprised about the data systems that police departments across this country have that they rely on. So, and we see this with trying to pull crime data out of the internal systems as well. That those source systems we're not as comfortable with, and sometimes the quality and the integrity of the data that we want to make sure is where it should be, because then that diminishes. Obviously, if we have disparate systems producing disparate sets of data, and this gets out to the court, to the public, that obviously impacts the trust that the public has in the police department, whether it's crime numbers or use of force numbers or Terry stop data as well.
So help me understand this. Is there the equivalent of an IP or an IT department inside the Seattle Police?
Yes, sir. There's an IT department, and again, that's along with moving the Training and Compliance Bureau to be a direct report to me. The IT section will now directly report to me. We have also put in a request to the city. We currently have an IT director to have a chief information officer as well, because even going forward, to help us obtain compliance, but more broadly to deal with all our information systems inside the police department, we think we need even more assistance given the necessity of the data to reassure the public that the police department is a data-driven department. And lastly, I'll just say one thing. Again, with the leadership of Chief O'Toole, and she's absolutely correct in terms of her discussions internally and holding us accountable. This is our #1 priority. And while the chief described me in the paper as a nice guy, I didn't come here to make friends. So we will hold people accountable to make sure that we achieve those deadlines going forward. And again, I think by some of the restructuring we've done and some of the personnel moves, those are some of the first steps. And we hope when we come before you again, we're having a pleasant conversation about all the progress we are making in terms of achieving compliance.
Are you familiar at all with the dashboard camera situation?
I am not as familiar, and Ms. Moorhead was just explaining it more to me, so I would have to defer to her on that.
All right. Well, then we'll have her take the podium. Thank you, sir.
Thank you, Your Honor.
Ms. Moorhead, nice to see you again.
You too, Your Honor. Thank you. Last time we were before you in April, there were some significant problems with the department's in-camera video system. The upgrade from the vendor had caused a series of problems, including dropped frames, which was simply unacceptable. Now I'm glad to report that those problems have been resolved and the system is working as it should. The department has also issued a directive requiring officers to check the batteries, make sure that they deploy with an on-body microphone that's fully charged, and the department has put systems in place to make sure that supervisors are holding their officers accountable and supervisors are accountable for making sure that officers deploy with an on-body microphone that's charged and fully working.
Are you tracking the statistics in order to represent to the court the next time you're here that we have 100% compliance with that directive? I mean, I understand that if nothing happens, there's not going to be any, way to know. But if we have an incident, am I going to be able to be assured by the department that there is compliance with those directives? Because that's, frankly, let's be blunt about this, there has been the heavy implication throughout this that it's officer discretion and we're just not going to turn these things on, even though the court's view is they're the best friend that they have. So are we tracking that?
It's absolutely not discretionary. They need to turn it on when the policy requires it. And to that end, we are voluntarily revising the policy to make that even clearer. If officers are not turning it on when they should be held accountable. So I believe we'll be in the position to be able to report how many complaints, for example, were made to OPA, Office of Professional Accountability, related to use of the ICV system. Another way that we're ensuring...
isn't the appropriate person to lodge a complaint the sergeant who's supervising this? I mean, why does the citizen have to say the department's not following its own directive?
Under department policy, complaints to OPA can be initiated by citizens or by any member of the department. And indeed, officers have the obligation, if they're aware of potential misconduct, to report it to OPA. So if a supervisor is seeing that his or her, a member of his or her squad is not turning on their ICV when they're supposed to, they should be held accountable. And another check on this system, there's the supervision who should be checking to ensure that officers are using the system appropriately. The Use of Force Review Board is also reviewing all of the most serious uses of force, and they are also flagging the issue when they see it. That's one of the things that they review for, is to determine if ICV was available, if not, why not, and if there's an officer that needs to be held accountable, they make referrals directly to OPA. We don't wait for citizens to make those complaints.
All right, well, let me put a marker in the sand. When you come back, meaning the city, I expect that we're going to be told that any time a sergeant is aware that there has not been compliance with this directive, that a statistic has been kept about that, so that we know. I mean, I can make all of the pronouncements that I want, and if they're not being implemented, it doesn't help us. And I want some assurance that we're tracking that to find out.
Absolutely, Your Honor.
All right. Thank you very much.
May I make a couple concluding points
Absolutely.
about the pending motion? I don't want to leave the court with the misimpression that data is not being collected. The department has an obligation to collect data, and they're doing so now. At the suggestion of the monitor, they've implemented the new IA Pro computer system, which is
When was that implemented?
It was implemented, I believe, in April of this year.
I mean, once again, part of this is, and by the way, I'm extremely pleased that you all consented to videotape this recording, or this hearing, so that to the extent anyone wants to watch it, they have that opportunity. Because I think the more the public knows what we do here, the greater assurance they're going to have that we're trying to address some of these issues. So I appreciate your cooperation in that. The question that I guess I have is, we had some original systems that apparently we have concluded at some point are so worthless that they need to be scrapped, because we just can't verify the significance or the accuracy of what they're recording. Very recently, we've adopted the IM Pro system, which is going to be a stopgap that hopefully will get us to the proposal that will allow ultimately a business information system that tracks this. Am I correct in my chronology?
That is correct, Your Honor. And meanwhile, significant work has been done in other areas too, in terms of policy development and training. It's been an active department in over the scope of the reform effort.
All right. I'm sorry to interrupt.
No, I appreciate your question, and we also, the city also is happy that this proceeding is being recorded so that we can be transparent for the public. I wanted to say, in regards to the motion, the city is capturing data, we believe accurate, reliable data in IA Pro on many fronts. Officers are entering all of their use of force information into that system. Use of Force Review Board is using it to track incidents. OPA is using it to track complaints and investigations. The vendor, at our request, is developing a new module on Terry stops. And so the system itself can capture a significant amount of data. So I didn't want to leave you with the misimpression that we're not collecting any data. In terms of the motion, there was agreement among the parties with DOJ and the monitor that back in June, that we would pause development of the RFP, essentially so that tasks could be reordered. The initial plan was to issue the RFP at the end of July, then ask the vendor, the would-be vendor, to come in and analyze those existing source systems and the data integrity. At the suggestion of the monitor, the department realized that a better ordering of those tasks would be much more productive and efficient, and would allow for a better RFP and clearer direction to would-be vendors. So it was decided and agreed upon that the city would first work on cleaning up those existing systems, determining which would feed into the BI system, analyzing the data integrity and making improvements there when needed, and then issue the RFP. So it's our hope and our expectation that this delay won't push the development of the system out a corresponding amount of time, but will instead result in the same amount of time for the system to be created, but just reorder those tasks. And so our hope is that this extension will make the process much more efficient and streamlined. And I just want to underscore how important the process is. The department very much needs accurate data and a manageable way to store it. And so we want to make sure we get the process right. We want to issue an RFP that's meaningful and will get us the system that we need.
All right, thank you.
Thank you, Your Honor.
As a general caution to all of the parties in this, in the future, the court expects that motions to extend deadlines will be noted for decision prior to the deadline extension. I think the deadline in this matter was July 30th. The motion was filed on July 29th. To the extent that there are contested motions, there's about a 28-day delay in getting those motions heard, which means you're going to be out of compliance. And I'm sure none of you want to be in contempt of court, so we'll try and work on that schedule. Mr. Diaz, are you speaking for the government today?
I am, Your Honor. Thank you. May it please the Court, Your Honor. Before directly addressing your second question as to what is the effect of the business intelligence system being pushed out until March of 2015, I wanted to address a couple other things first. That issue and your well-taken concerns, Your Honor, highlight for us one of the distinguishing features of the consent decree, namely that it's baked into the consent decree to continually reassess what's working and what's not. In other words, there are mechanisms of self-correction built right into the consent decree. And the business intelligence system is an example of this. We're not going to rush to meet deadlines for their own sake at the expense of getting this right. And we agree with the city, and I suspect we're going to agree with the monitor when they come up to speak as well, that now is not the right time to do an RFP, and that the earlier project plans weren't sufficient or weren't efficient and could have caused more delay than necessary. And that's why we didn't oppose the motion. And similarly, Your Honor, if you can indulge me for 1 second, we are now reviewing, along with others at the CPC, how the policies and the training that have already been approved by this court are working. We're aware that there have been reports of use of force reporting leading to police officers being taken off the streets to do unwieldy paperwork. So far, when we've asked for information, it seems to be based on repeated anecdotes and is contrary to some of the hard data that we've actually seen. For example, the form for minor force handcuffing pain is a total of 6 questions, at least as envisioned in the consent decree that you signed, and is taking line officers 15 minutes to complete. Nonetheless, because there are mechanisms of self-correction, we're looking at that and currently discussing with SPD how to both get the information needed to make any revisions and get systems in place to answer the questions, flag concerns, and retrain as needed. And we'll self-correct as needed. But again, we have to remember that anecdote is just that, and our review will be based on objective data reviewed by the right personnel, internal and external to SPD. So in short, what we're aiming at here, Your Honor, through these mechanisms of self-corrections to ensure that we're satisfying the requirements of constitutional policing as laid out in the consent decree.
Mr. Diaz, you might want to slow down one beat, or you're not going to have much of a transcript.
Okay, I just get really excited about constitutional policing. And we're also meeting the needs and the realities of urban policing, both in the BI system and the trainings, the forms, and everything else. So with that, now turning to your second question, I think the one that you wanted us to answer here today, Your Honor, a little bit of background on what the consent decree says. And you are right that paragraph 229 of the consent decree says that the parties anticipate that the city will have reached term of art, full and effective compliance with this agreement within 5 years of its effective date. 3 years for compliance wasn't suggested at any point. And the reason behind the 5 years was it was basically broken up into 3 phases. There was a development of the written policies, the rules of the road for the officers, and we talked about that in April and the importance of that. Then the development of the training, not just the creation of the written curricula, but also the massive effort of administering it to up to 1,300 officers per training material. And then finally, having officers, the third phase is having officers carry out the policies and training in practice. By the end of this year, Your Honor, the first 2 phases will almost be entirely complete. So we can next turn to the third and final phase, the determination of full and effective compliance. And the key to this third phase, and you pointed this out, Your Honor, as well, is that, and why it's good to talk about it now, is that paragraphs 229 and 230 say that the department has to hold compliance for 2 years to make sure it sticks. So 1 good day, 1 good month, 1 good year isn't enough under the consent decree. So before turning to what full and effective compliance means, I do want to address the concern that we're here now 25 months into it. We've developed a timeline, a chronology of events, and a demonstrative, which I'd like to provide to the court after the hearing. In a nutshell, we've been at this actually for about 18 months, and it's followed the pattern of the consent decree and the monitoring plans in place. We didn't have the monitor in place until October of 2012. The consent decree gave the monitor only 4 months to get his feet on the ground and develop a monitoring plan, which wasn't in place until March 2013. The consent decree was a framework, and the monitoring plan was the details, filling in that framework. And since then, Mrs. Moorhead has already gone over this. A lot of 2013 was devoted to policies and setting up these, what we call in our maybe a little bit too DCEs, is the Systems of Critical Self-Analysis and Self-Correction, the CPC, the Crisis Intervention Committee, the Use of Force Review Board, the FIT team. Took a lot of time to set up. So the upshot, though, is despite only being at this for about 18 months, we're now going into the final phase of full and effective compliance. So what is full effective compliance? Full and effective compliance under paragraph 182 says the city may demonstrate it in either through compliance reviews and audits, so on the one hand reviews and audits, or through outcome assessments. These are two routes or prongs to reach full and effective compliance, which is the standard for termination of the consent decree, the dissolution of the consent decree. Under the first prong, under the reviews and audits prong, here what full and effective compliance is under the consent decree is three things. Incorporating, and this is straight out of the consent decree, and this is not just for Your Honor, but also for some members of the gallery as well to understand. It's incorporating the requirements into policy. It's training all relevant personnel to fulfill their duties. And then finally, ensuring, and this is my favorite line in the consent decree, requiring that it's carried out in practice. You have to do it. You have to do it consistently. So it goes on to say that paragraph 184 goes on to say that the reviews and audits, the first prong, will contain both qualitative and quantitative elements as necessary for reliability and comprehensiveness. Those reviews and audits DOJ hopes to start conducting in the spring of 2015. And the parties in the monitor have been in discussions about these reviews and audits, and we plan to meet as early as next month to discuss what and how we measure compliance under this first prong. What are these reviews? What are these audits? Not just quantitative, but qualitative. And at this point, Your Honor, and I think this now directly answers your question, is the Department of Justice has no reason to believe the department can't make it in 5 years. And the DOJ, under this first prong, has no reason to believe the data systems, including the business intelligence system, will slow us down. But we have to emphasize, and I think this is probably the most important point as we move into this third phase, it is now up to line officers and their supervisors to do what they were taught in training and required to do and are required to do by policy. They either will do it or they won't do it. And the sooner they do it, the sooner we can start wrapping up. So that's the first prong. And the second prong, this will be my final point, Your Honor, that prong is less certain. Paragraph 187 says the department can show full and effective compliance by means of outcome assessments. All right, this is the second prong. The department theoretically could have run these after year 3. Outcome assessments, in contrast to reviews and audits, are purely data-driven measures that show that the purposes of the consent decree have been met and there are no unintended consequences. Even if the city didn't meet the reviews and audits in the first prong. Again, we have no reason to believe that the databases, either IA Pro or the BI system, will not be in the state to do the outcome assessments, maybe not by year 3, which is the earliest they could have done it, but by year 5. But for us right now, it's wait and see on the business intelligence system and on IA Pro. Will they be able to provide the data necessary to do the second prong of full and effective compliance?
Your math doesn't make sense to me.
Okay.
You got 3 years to get the business information system up and running. It may take longer than that. It's going to have to be up and running and then a 2-year period of compliance. Optimistically, that's 5 years. Realistically, that sounds like more 6 or 7. That's what my concern is. I mean, This is an expensive process. It ties up a lot of resources. It occupies a great deal of attention from the police, from policing to police techniques. Those and the people of Seattle are denied the protections of constitutional policing until it's up and running. So, I understand that's what my concern is we just keep, sort of saying, well, for 2 years we've developed a lot of policies. We've got all of these topics that are left. You're not going to get by this court without some review of the disciplinary process. Because the disciplinary process, we have another example of it in the paper this morning, an action taken in regards to restoring someone to patrol duty, when the public's going to question if they wrote on their official documents a nickname for a city official, they would find that to be somewhere between insubordination and abhorrent judgment. Those kinds of questions are out there. If you're going to have the full faith and support of the public in Seattle, they're going to have to be proud of their police. And that's going to be the biggest weapon the police have. We don't need armored personnel carriers. We need the public to support us. And I want to make sure that we get there as quickly as we can, employing absolutely the maximum effort and best techniques that we can get. So I hear you, but I'm unpersuaded by your math.
Yeah, let me, if I can, Your Honor. First of all, we entirely agree that the goal, it's in the first paragraph, as Your Honor read in the first hearing that we had on this matter. The community trust is in the police department is the goal of the consent decree. That said, that there are technical steps that we take in this process. And then the first prong, unlike the second prong, it's more holistic. You're looking at, are the officers, for example, minimally relying on force in a systemic way? Are they using their de-escalation techniques? Are they reporting force to a greater degree and more accurately and more usefully for their supervisors? Are the supervisors acting on this? That is a holistic look. It's a qualitative look at individual interactions between the police and the community. And as we did in 2011 during our investigation, we will look at a statistically valid sample of these interactions and see, are they doing the new things that they're supposed to be doing systemically? Not one here, one there, but in a systemic way. And that's what the first prong is. Data plays a role in it. The consent decree says that. Data plays a role in that. And I think what's important that the city said was that they are already starting to capture some of this data. IA Pro will capture some of it, and we'll see where that data piece goes. But that doesn't stop us, Your Honor, from as early as, we hope, it doesn't stop us as early as next year to begin doing those reviews and audits and satisfying the first prong. The BI system is indispensable for the second prong. And if that's the method the city wants to avail themselves to get out from under the consent decree, then it's going to be a closer call for those 5 years. But if they get in compliance and then can sustain that for 2 years, I still think we're within that 5 year window. Again, it's going to depend ultimately on the individual interactions between individual police officers and individual supervisors in the community. The onus is shifted from the policy unit, the training unit, the command, to individual people interacting with individually constitutionally. And we're not going to leave until we can have a firm belief that they are doing what they're supposed to be doing systemically.
All right.
So, thank you, Your Honor.
Thank you, sir. Bob?
May I speak from here, Your Honor?
You certainly may, sir.
Thank you very much. You posed a couple of questions. Let me take the second question first. How did we get here? And I think we got here because much of the first year of the monitoring, there was intransigence and passive aggression, an effort to defeat the consent decree, an effort to defeat the monitoring. The second year, or much of the second year, I would charge some of it to that, continuing intransigence. But as regards IA Pro and the business intelligence system, I would say incompetence. And that there were not people in charge of those efforts, specifically in charge of those efforts, who were capable of producing it. And what was produced was error-ridden and had to be redone. That, I think, brings us to the current state. And the current state, I see as significantly different from what occurred previously. First, we have a mayor, we have a chief of police, we have a city attorney's office, and we have the United States all working together in a far more cooperative and collaborative way. There has been a wholesale change in personnel and reporting within the department. In less than a month, Chief O'Toole has very much restructured those relationships and put people in charge who we have every confidence can do the job. Therefore, I think that although we sincerely regret that it was unable to be done by now, and certainly used our best efforts to push the department, I think that we are now at the point where the Chief O'Toole, the monitoring team, and others are sufficiently of one mind that we will get some good progress from it. The other thing that I would point out is that the business intelligence system, of course, is a vital component of the consent decree, and we find it very difficult to imagine full and effective compliance without it working. For one thing, it will give the data that is necessary to make the judgments that you yourself have described. Second, IA Pro is up and running, but in a very narrow way, in that officers are now able to report use of force. That is the only thing they can do using IA Pro. There needs to be a module developed so that it can report stops, pedestrian stops, traffic stops, all the Terry stops, and so forth. That is at the beginnings of being in development. We will need ultimately for IA Pro to have a litigation module so that we know what litigation is pending, what the issues in the litigation are, and how they report. We need to track use of force, we need to track the Use of Force Review Board and their findings and deliberations. OPA needs to have IA Pro improve so that it meets their needs. So IA Pro is there, and officers are beginning to record their use of force, but that is not the only stopgap that's necessary for data pending the business intelligence system. So there's still work to be done there. Again, I have a great deal of confidence that it will be done. For one thing, Captain Kaler, who is here today, has been put in charge, reporting to Mike Wagers. And Tag Gleason. I think that we'll get stuff done. And it is for those reasons that, you know, it was our monitoring plan approved by Your Honor that set these deadlines. And I am very reluctant to see them slide. The court mentioned how there really was not much of a choice at this point. And I'm afraid I have to agree with the court on that. But I can pledge to the court that I will be, and my team will be, looking very carefully and consistently at the progress in these areas and lending our assistance, technical or otherwise, to get the project moving. As regards ICV, the internal the cameras are still having some problems with the audio. Officers are failing to turn them on or turn them off too quickly. And we're still waiting for the department to propose to us some updated policies with respect to bias policing. I'm certain that we will get those in good order, but I don't want to leave you with the impression that there are no problems with the cameras. There are. And it will take data, as you have described, to spot those problems. The Use of Force Review Board, which reviews all significant force, always has available to it, if it is available, the in-car video. If it's not, the Use of Force Review Board notes that. And I think we will be doing more by way of spot checking and spot auditing to make sure that it is being properly recorded. With that, Your Honor, I'd be happy to answer any questions you have.
You only get to talk to anytime I need, so I don't have any questions for right now. Do any of the parties wish to add anything else before I close this proceeding? Mr. Diaz?
No, thank you, Your Honor.
All right.
I would very briefly, Your Honor.
Certainly.
Thank you, Your Honor. Your Honor, I just wanted to underscore one point quickly, and that is that constitutional policing in the City of Seattle is not awaiting a business intelligence system. At the time, right now, there is an extensive new use of force policy in place giving clear, detailed directions to officers. Officers have received detailed, in-depth training this year on stops and detentions, use of force, numerous other areas. They're being held accountable when they're not acting constitutionally. We have a new force investigation team who is investigating the most serious uses of force. Sergeants are doing detailed reviews of the others. Use of Force Review Board then does another review of the most serious uses of force, all but type 1 they review. So I don't want to leave the misimpression that we're waiting, because we're not waiting for the computer system. If one is going to review a particular incident to determine if the actions of the officer were constitutional, you don't go to a database to determine if that use of force, for example, was constitutional. The court, for example, would review all of the available evidence, just like a sergeant does, just like the Use of Force Review Board does, and they're doing that now, reviewing each incident to determine if it was constitutional, and they're very thorough reviews. So I just wanted to make it clear that constitutional policing is not awaiting a more refined computer system.
Thank you.
Thank you.
As is my prerogative, I will close this hearing with some brief remarks. Let me begin by thanking Chief O'Toole. And I guess we refer to you as Mr. Majors.
Yes, Your Honor.
You officially don't have a police title, as I understand it.
Chief Operating, no, I do not have a police title.
Yeah, I was going to call you the Chief Operating Officer, but both for undertaking this significant responsibility and also coming here today. And secondly, I'd like to thank the monitoring team. I don't think many members of the public understand that notwithstanding the substantial expense associated with this process, the gentlemen sitting over here donate the majority of their time or a very significant portion of their time on a pro bono basis. And at least I thank you for that. Not sure that buys much at Starbucks, but you have the court's thanks. While I'm passing out comments, I also would mention the community police effort. I'm in receipt of the Community Police Commission's follow-up assessment, which I thought was thorough and which I appreciated receiving. I'm glad we're moving back towards what I think was the role envisioned for the Community Policing Commission in both the settlement agreement and the memorandum of understanding. I don't believe that they were created to give advice on the technical details of policing, but I thought that their work in regards to the assessment was valuable, and I'm sure will receive attention inside the department. The term full and effective compliance with the settlement agreement has been bandied around some this morning. That takes into compliance almost everything the Seattle Police does or do. And that's what I'm going to measure. That's what I'm required to measure under the written standards that are found in the settlement agreement. And there needs to be a 2-year period while that happens. The business intelligence system doesn't tell you if there is or is not full and effective compliance, but it does give me the information that allows me to make that judgment. And that's why I have taken such a keen interest in this. And I will take a keen interest this fall in what is something that will happen outside the parameters of this courtroom, which is the collective bargaining process between the police and the Officers Guild. I have previously spoken to the fact that that's something that I would like to see the parties handle themselves, but is subject to a test by the court of the question of full and complete and effective compliance with the settlement agreement and the parameters of constitutional policing as set by the United States Supreme Court. So we have our work to do. Finally, Mr. Diaz used a phrase today that I'm going to ban from further use in this courtroom, which when he said, "Get out from under the settlement agreement." I don't see this as a matter of getting out from under anything. What I think we're talking about is achieving full compliance with it. Once it's not there, the obligation of constitutional policing remains, and that obligation is one that is paramount at all times. To the parties, I have formally signed the order granting the City of Seattle's motion to extend the deadline to submit a request for proposals to build a business intelligence system, found in the docket, I believe, at entry 163, and will return it to the clerk for filing at this time. And my thanks to the parties for coming in for today's hearing. We will be in recess. Thank you, Council.
All rise, please. Court is in recess.
You ever had a client?
Yeah.
We'll do that.